Welcome back. We have been watching defense closing arguments. That was the defense attorney for Frankie Gebhardt, who was on trial for murdering Timothy Coggins back in 1983. This cold case that investigators were finally able to crack last year when new evidence and new witnesses came forward. Adam Sostrin, criminal defense attorney, is with me live via Skype from Los Angeles. Adam, I want to talk a little bit about the defense's strategy here. Before we play this beginning of the closing arguments, we talked about how some of the evidence had been lost and how that over the course of 35 years and how that definitely made it a little bit more difficult for the prosecution to prove their case. Here we hear the defense attorney hitting on it again and again. Evidence was lost. Why wouldn't they put these critical hairs found at the scene away in a bag and seal it and put it in a bigger box? Why wouldn't they do a better job at preserving this evidence? He said this was a crime scene that screamed for justice, and it didn't get it because law enforcement did a sloppy job. How important is that to jurors when they consider this case?
Well, I suppose if you're a juror, you might think in a case that's this important, you would expect where the district attorney's office has a duty to prove his or her case beyond a reasonable doubt, that the police department they're working with would take every measure to ensure that the jury gets all the evidence it deserves to receive, to analyze, in order to make such an important decision on a case in which a defendant is indeed charged with murder. So you may be thinking, well, maybe it's sort of a slipshod investigation. You might think, well, perhaps did this evidence not exist to begin with, and that's why it's nowhere to be found. So any which way, the defense attorney has to create some sort of doubt or questions in the minds of the jurors, and I suppose that would be the purpose for talking about that, the way the defense attorney is during closing.
Yeah, and I mean, we're looking at some photos here of prosecutors holding up some pieces of evidence. So it's not that there was no evidence in this case. It was just that a lot of key pieces were lost over the years. One other point I want to touch on is many of the witnesses in this case, you say Frank Gebhardt confessed in part to this murder, were people he met in jail. They were people, cellmates and so on and so forth. And we heard the defense attorney really trying to discredit them, saying, look, these are guys who made up a story just so they could get a break from prosecutors, although not all these witnesses were given a break by prosecutors. In fact, prosecutors refused to give a deal to a number of them. But still, how much does that discredit the witnesses, and how, what is the credibility of jailhouse witnesses? What is that typically like?
Well, I guess jailhouse snitches or informants are kind of treated like podiatrists in the medical profession. Not to say anything bad about your podiatrist, because I like mine. But unfortunately, when jurors do, or fortunately, when jurors do hear that evidence, they are supposed to sort of take it with a grain of salt, that there may have been some sort of offer given in exchange for helpful testimony for the state. And the fact that, of course, some of these witnesses were made no offers whatsoever, that would certainly not be helpful to the defense. That's sort of something the prosecution has, and the defense can't do anything about it. What would be the motive? Is it celebrity? Is it sort of notoriety? If it's not in exchange for some sort of mitigation to a sentence that a jailhouse informant is currently serving, what is it? So the jurors, again, just like with the rest of the closing argument, they sort of ask, the purpose of the defense's statements is to make the jurors question the evidence that's being placed before them, which includes some of the live testimony that they're hearing during the trial. But yeah, I guess podiatrist would be my answer.
Well, I don't know how nice that is to podiatrists. Like you said, I like my podiatrist too. We're going to take a quick break. When we come back, we're going to have more from the closing arguments in this murder trial. Stay with us. Welcome back. We've been listening to Frank Gebhardt's defense attorney give some of his closing arguments in the murder trial. Frank Gebhardt on trial for murdering Timothy Coggins, a young black man, back in 1983. We have been revisiting highlights from this cold case all day today, and in just a little while, we will replay you the verdict. Did the jury decide that Frank Gebhardt was guilty, or did they find some reasonable doubt and acquit him? That's going to be coming up in just a minute. But first, Adam Sostrin, criminal defense attorney, still with me via Skype. Adam, we've already talked about a few of the defense's points here. One, really trying to play up the fact that the state lost a lot of key evidence over the years. The other point, trying to really discredit a lot of these witnesses, whether they're jailhouse witnesses, whether they're friends or associates of the victim whose stories changed a bit over the course of 35 years. First, I just want to ask you about that. I mean, we spoke about jailhouse informants before and how credible they are and whether or not really they are to be believed. But when you have regular witnesses or associates of a victim, people testifying who maybe have changed their stories or added some details over the course of 35 years. I mean, it's not surprising, right? I mean, whose memory is that good to remember everything that clearly? Is it surprising to you that they may present some new details, though?
Well, you know, at the time, sometimes you make a statement and you didn't say the whole thing. People have all kinds of issues with respect to memory. People have issues if they witness a robbery or what the person looked like. People have issues with cross-racial ID. The bottom line is we're imperfect beings and our memories aren't perfect. But of course, it is a ground of attack. It's something that's appropriate for the defense to raise, because if there are issues with respect to statements that they're making, and if the statement is different or if there's embellishment, of course they have to bring that up. Because if you're the jurors, what you want to rely on, what you want to count on, are the statements that were first made at the time of the offense, not statements that were made 30 to 35 years later. That should be of less import. You're supposed to focus on what happened before. So I think that, sure, the defense wants to raise these things because he wants the jurors to think that perhaps they're giving false information, but the jurors, they really want to focus on what happened at the very beginning. And this is something that always occurs in any trial when the facts are so old and so stale. That's why people have rights to things that are called speedy trials, because over time, evidence is gone, memories fade, and this is precisely what that is.
Yeah, definitely a good point there. There's one other thing I want to discuss, and we may continue our discussion in a bit, but that's about DNA. I mean, back in 1983, there was no DNA testing, and technology has evolved so much. How much does that play in a part in a case? I mean, a lot of people watch crime TV shows and they think DNA is the be-all, end-all. When you don't have DNA in a case because it's this far back, does that make a difference to jurors, when they're so used to hearing about DNA evidence? And, well, if the guy's DNA was not at the scene, it must not have been him?
I have to tell you, one of the most annoying things that any defense attorney has to live with is every single jury trial, the green prosecutor tells the jurors, hey, do you guys watch CSI? Do you expect us to have all the technology that the actors had on CSI? And it is so annoying. I can't even I don't even want to talk about it. I find it so annoying. But it's something that happens in every single case. Jurors, of course, can't expect what we watch on movies for what occurs on the ground. Technology's changed over time, but the mere fact that that happens in every single trial, it still drives me nuts.
Right. Well, that is a good point, and I have heard myself being in some courtrooms, those references to the crime TV shows, because what happens on TV is not always what happens in real life, right? We're going to take a quick break. When we come back, we're going to have more closing arguments from this case, and in just a few minutes, we will be playing you the verdict, so be sure to stay with us. Thanks for that summary, Anthony. Again, jury selection set to begin on Monday in that trial out of the St. Petersburg, Florida area. Adam Sostrin, criminal defense attorney, is still with us via Skype from Los Angeles. Adam, what jumps out to me here is the defense's theory that they plan to argue involuntary intoxication and claim that James Colley was under the influence of Ambien at the time. Is that going to fly? He was under Ambien, so that caused him to all of a sudden shoot and kill his wife and her friend and go after two others in the home?
It's pretty incredible, but again, this is a case. Although we haven't talked about it, you and I personally, or on Skype or on Law&Crime, but this is a case arising out of Florida. So this is the Ambien case, and presumably other defense attorneys may soon follow. Involuntary intoxication is not an easy defense to get in front of the jurors. There has to be a hearing with the judge, and the judge has to determine whether or not there are enough facts that would allow that to even be presented. And it has to be to such an extent that they really have no control over their actions. And often these cases have to do with the fact that, they didn't know that it was going to have this effect on them. Of course, they themselves put it in the system, but it was, the drug effects were so surprising that they lost all control. They're going to have to pay for experts for a lot. There's going to be a battle of the experts between the defense and the prosecutor to see if this can even fly. It may not. It may not happen, and I wouldn't be surprised. The court has control over what evidence the jurors are going to see. So although we're talking about that now, it may never occur in front of a jury.
Yeah, I mean, it's interesting because I did a little reading online, and you probably are aware of this as a defense attorney, but right, there's this thing as the Ambien defense. It's not totally uncommon for people to use it. I mean, look at the last big public example, right? Roseanne Barr claiming that taking Ambien is what caused her to put out that racist tweet that led to ABC canceling her show. Of course, that is a much, much, much less serious offense than murder or assault or some of the other cases where defense attorneys have claimed Ambien caused their clients to do it. I'm wondering, have you been involved in any cases or had any clients who claimed that Ambien influenced their actions and caused them to commit a crime?
No, but if Roseanne wishes to contact me, if somehow I can be of assistance to her, just like any client accused of any type of crime, I will gladly have her in. We'll have a discussion about it, and it'd be interesting.
Well, I think Roseanne wasn't charged with a crime, right? Just accused of being nasty and racist on Twitter.
Yes.
So, but we will certainly pass that message along if we do contact her in the future. But in terms of using this argument in court, what is your experience or your interpretation? I mean, you mentioned it's going to be a battle of the experts, right? So when you say experts, what are we talking about here? Pharmaceutical experts, doctors? Who might we expect to hear from?
I imagine, it's a murder case. You're going to hear from everyone. You're going to have an expert that would say, depending on the dosage of the drug, is it possible that the person's not able to understand their actions? And you're going to have somebody from the state saying, come on, of course they could, and this is absurd. But that's going to be a battle that takes place with the judge and the attorneys on the case. It's not going to be in front of a jury, and the judge is going to determine whether or not there are sufficient facts that can go forward, as a defense for the defendant to a murder charge. And of course, while the defendant, there is no charge that's more serious, and then in a sense, then the judge should be a little bit more giving with what defenses that are put on. But the court cannot allow some type of a false evidence or a fraud, upon the court and in front of the jurors. So that's why the judge is called the gatekeeper, and he decides whether or not that evidence can even take place. So if Ambien doesn't work, they're going to have to come up with something else.
Right. I mean, look, I don't know. We have yet to see all of the details of the case for sure. But, I mean, to me, that seems like a stretch. I could see, okay, maybe, God forbid you get behind the wheel or something with Ambien and that causes a crash, but to murder someone. And the other thing that prosecutors are going to likely try to prove here is that there was premeditation, there was intent here, because as we heard in Anthony's recap on the backstory here, James Colley had been separated from his wife. She already had a restraining order against him, and they had been in court just earlier that day. Apparently, James Colley told his father he was furious after the court hearing that morning. His father told investigators that.
Sure.
And his father apparently also said that after the shootings, his son called him and said he just shot his wife and her friend. I mean, essentially, that's a confession, though not to law enforcement. I mean, that seems like that could prove the case in itself.
Yeah, it certainly doesn't sound like the Ambien made him so confused that he wasn't able to understand his actions. And certainly if there had been indeed a court hearing earlier in the day, obviously Ambien wasn't affecting him to the extent that the judge didn't feel at that earlier hearing that he could enter into a lawful order. So it does seem like you have some premeditation, you have some anger, you have motive, you have all those things, and you have a defense that it's probably not going to fly.
Yeah, you know, I'm wondering, in your opinion, we talked about the ambient defense they're going to use. Clearly, it doesn't seem like this is going to be a case of who done it, right? I mean, if they're going to use this ambient defense, then they can't claim that it wasn't their client.
Roseanne? Can they insert Roseanne? Probably not.
Right, going along with that ambient theme. But if you're the defense attorney in this case, knowing what you know, how difficult a case is this? How difficult a defendant is this to defend?
Well, I guess based on the facts that you're giving me, the defense may very well be hoping for some sort of, it's called voluntary manslaughter, some sort of heat of passion defense, where the person, you catch somebody, you've heard it before, somebody's cheating on you, or some other terrible thing occurs right in front of your eyes, and you just react. You don't premeditate, you react, and who the heck knows what those two things mean and why they're different. But in a murder case, there has to be premeditation. In a voluntary manslaughter case, there has to be something called heat of passion. So if you're the defense attorney, you're going to hope that perhaps the person was so. The argument you're going to want to be in front of you're going to want to place in front of the jurors is going to be, this person was so worked up based on what occurred, and perhaps. I don't think they're going to be able to bring in this medication, but you're always hoping to lessen the charges. You can't just get your client off. The district attorney has the same police report that you have, and it says all the things that, more things than what we're talking about right now. And, it's a hope and a prayer, but, you get life or worse for murder. For voluntary manslaughter, you don't get those things, so that's perhaps what the defense attorney is going to be shooting for.
Yeah, and let's not forget, in addition to allegedly telling his father that he had shot his wife and her friend, there were two other witnesses in the house at this time, including the wife's new boyfriend. So I think this will be an interesting trial and a lot of interesting witness testimony. Yep. Again, jury selection gets underway on Monday. It could take up to a week, but we will be bringing you all of the courtroom drama in this case live right here on the Law and Crime Network. Well, coming up, we're going to have the verdict in the Frank Gebhardt case. Did the jury find him guilty of murder, or did they acquit him in this 35-year-old cold case? Stay with us. That verdict coming up right after this break. I'm Stacey Delikat. Well, it is now time to get to the verdict in the murder case of Frank Gebhardt. Just to bring you up to speed once more, this was a 1983 murder. 23-year-old Timothy Coggins brutally murdered. Police called it a heinous crime. He was beaten. He was stabbed. He was dragged behind a truck. His bloody body ditched in a field. Prosecutors allege that Frank Gebhardt and his brother-in-law, Bill Moore, committed the murder. They say it was a racially motivated crime, that the men killed Coggins because Coggins was talking to a white man, a white woman who witnesses say may have been Frank Gebhardt's girlfriend. Well, this was a case that drew national attention because it was cold for 3.5 decades. Then last year, some new witnesses came forward, some new evidence became apparent. Police announced a break in the case, made these two arrests. It is a case that has drawn national attention because it is such an old case and because of all of this racial motivation that prosecutors alleged was involved. So after both sides summed up their arguments, the judge delivered the case to the jury. They deliberated 6 hours. Here is the verdict they came up with.
In the Superior Court of Spalding County, State of Georgia versus William Franklin Gebhardt, defendant, criminal action number 18R105A. Having considered whether the state has proven each element of the following offenses, we, the jury, unanimously find as follows: Count 1, malice murder, guilty. Count 2, felony murder, guilty. Count 3, aggravated battery, guilty. Count 4, aggravated assault, guilty. Count 5, concealing the death of another, guilty. Signed this 26th day of June 2018, signed by their foreperson. Do y'all wish to look at the verdict form?
Well, there you have it. The jury deciding guilty on malice murder, guilty on felony murder, aggravated assault, aggravated battery, concealing the death of another. Frank Gebhardt didn't really react after this verdict was read. Certainly, there was great relief from the family members of Timothy Coggins. His parents passed away several years ago, still hoping they would have justice for their son. They did not live, unfortunately, to see this moment. In just a few minutes, we're going to play a victim impact statement from one of Coggins' relatives. But Adam Sostrin, criminal defense attorney, still with me via Skype from Los Angeles. Are you surprised at this verdict at all? You know, it is an unusual case. This was a murder 35 years ago. A lot of the evidence was missing, but there were witnesses who said Frank Gebhardt had confessed and even sort of bragged in part about these murders. And there were witnesses who said they saw Frank Gebhardt, you know, at the same club where the victim was the last night he was seen. So are you surprised at how this all shook out?
So this is the type of case where the prosecutor generally doesn't make any kind of offer. At least that's what I'm assuming. And the defendant isn't just going to plead to murder. So the defense attorney goes to trial. Under the Sixth Amendment, you have this right to, you know, effective representation. You have a right to, you know, an attorney represent you at trial. Of course, this is, I'm presuming this is a privately retained attorney. I don't know the answer to that question, but it's irrelevant. When the only questions the defense can bring up are, how come they didn't preserve this physical evidence in a slide? Where are the missing slides? This person appears to be adding testimony to perhaps some of the damning testimony that they already gave 35 years ago. You don't have much. This is a case that went to a trial because the defendant had a right to a trial. Doesn't mean that it's a good case. Doesn't mean that it was very defensible. So I'm not surprised at all with the verdict.
Yeah, I mean, in a high-profile case like this, I mean, it did get national attention, everything, you know, from national news networks, the New York Times, and so forth. Like you said, prosecutors weren't going to make any kind of offer here. I mean, how much do you think sort of the emotional impact on the family, but just, you know, in the times we're living in, this area of Georgia, which is, I believe, a little less than 2 hours south of Atlanta, is a very different place today than it was in 1983. But we're living in a time when there are still so many issues regarding racism, regarding, you know, how crimes against black people are investigated versus crimes against white people and so on and so forth. And the allegation was that back in the 80s, no one really cared. This was just another black guy who was found dead, and that they really did not do their due diligence when investigating this. Police, prosecutors obviously felt they really needed to bring this case to justice. And how much do you think maybe jurors felt they wanted to see some justice for Timothy Coggins as well?
Well, they probably did. You know, if the backdrop is 35 years ago, Georgia, and it's clear to everyone that racism, it still exists. It was worse then, of course, than it is now. And the fact that the jurors thought they were getting some justice for the family and for the poor victim, yeah, that can't be understated. Of course, the jurors are they're not there, of course, to get justice. The purpose of the jury is to determine whether or not the district attorney can prove its case beyond a reasonable doubt. So they're not supposed to be thinking of those things. But if you're looking at it from, you know, somewhere up in the sky and you're looking down, certainly justice has finally come to this family, and it's so unfortunate to even imagine the fact that you know, a black man's talking to a white woman is grounds to kill somebody. It's so abhorrent. So justice was done. Of course, the purpose of the jurors isn't that, but justice appears to have been found in this case, and I do feel for the victim and the victim's family, it's so awful. So.
And of course, after a verdict comes down, when it is a guilty verdict, there is sentencing. And before the sentencing, there are victim impact statements. So now we want to, before we tell you what Frank Gebhardt was sentenced to by a judge, revisit a victim impact statement from one of Timothy Coggins' family members. Well, there you have it. Frank Gebhardt convicted, sentenced to life in prison in that 1983 racially motivated killing in Georgia of Timothy Coggins. The judge said, hopefully you have stabbed your last victim. Adam Sostrin, criminal defense attorney, still with me via Skype from Los Angeles. Thanks for being here, Adam. This is only one defendant who was charged in this case. Frank Gebhardt's brother-in-law will stand trial later this year. What does it mean that the jury already found Gebhardt guilty? Does it mean, you know, that in jury selection for Bill Moore's trial, they have to find people who know nothing about this trial? I mean, how does this influence that second trial?
Well, they're certainly gonna try their best. The point is, you're supposed to have a veneer, a bunch of jurors that are representative of the community. At the same time, they don't already harbor any biases towards the defendant. So, of course, questions are going to be asked. You know, it's a relatively small community where this event occurred. You know, if they're aware of any facts of the previous case, and is that going to affect them and their ability to be fair and impartial jurors here? And those are always unknowns. And nobody has any idea what effect that's going to have on their ability to be fair in this case. But the purpose of separating off the defendants is it's the idea being that it's not entirely fair for one defendant to be prejudiced by evidence against another. And so they separate them out. So there's going to be another trial. It's going to be a completely different set of jurors. And the goal of the defense attorney is going to be to find the fairest possible panel, if that's even possible. And then you go forward. And I would assume if the defense arguments are, well, how come we don't have slides, that perhaps it's going to lead to the same result.
Yeah, you know, I'm wondering how similar the cases will be, and we don't exactly know what Bill Moore's defense will be and whether or not his attorneys will say, you know, he played no role or he played a different role, he wasn't involved in the actual murder, right? Do you think the prosecution kind of sticks to their case, though, in terms of what they presented this time around?
Well, their witnesses can't make different statements. So, of course, the defense attorney is going to be trying the case. He's going to have transcripts for everything that occurred at the prior trial to be able to say, well, you know, witness one is saying something different than was said before, so obviously he can't be believed in the second trial that we're having right now. So those are some of the things that's going to occur. And yes, I do not know what the defense is that's going to be made. If it's something completely different, that's probably preferable. Because this one failed.
Yeah, absolutely. Well, we will just have to stay tuned for that second trial in the murder of Timothy Coggins. Adam, I want to thank you so much for being with us this afternoon. You gave some great insight and also a few good jokes along the way. So thank you so much for that, for keeping it light on this Friday afternoon. We thank you, as always, for being with us, and I'm sure we will talk with you again soon.
Okay.
In the meantime, coming up next, we are going to have a very special interview. It is a stunning case out of Ohio in which a man lit his girlfriend on fire. He threw gasoline all over her, then lit her on fire with a lighter. She was terribly injured, managed to survive for 700 days in a hospital with burns almost over her entire body before, sadly, she passed away. Well, the trial of her boyfriend was supposed to get underway next week, but today, this week, he took a plea that will give him life in prison. Coming up after this break, we are going to speak with the victim's mother about why she says her daughter did not die in vain. Stay with us. It will be a very compelling interview, and it's coming up right after this.